Hey there, in this video, I'm going to be sharing why I, as a criminal defense attorney, have the unpopular opinion that I am hoping for a not guilty verdict for Danny Masterson. My name's Veronica. I'm a criminal defense attorney here in California, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. Now, again, in this video, I'm going to be sharing with you my unpopular opinion that I think we should free Danny Masterson. I hope that the jury does. More importantly, the reasons behind that opinion. As of the time of this filming, we are awaiting the jury verdict in this second trial, in the retrial of Danny Masterson. So let's get right into it. Injustice number one is that the prosecution was able to retry Masterson in the first place. I mean, if fewer than half of the jurors are willing to convict in the first trial, why should they be allowed to keep going again and again and again and again? After the prosecution presented all of its evidence, all of its witnesses, the jury deliberated, and ultimately, fewer than half of them voted to convict on any of the counts. You would think that that should be the end of it, but that's actually not how it works. Because whenever a jury cannot unanimously agree, instead of the case being thrown out, what happens is that a mistrial is declared and the prosecution can choose to keep retrying the defendant again and again. And the really troubling thing to me about this is that if the defendant does not have the resources that Masterson has and he's in jail, he will sit there in jail until the prosecution either gets tired of trying the case, until the judge decides that he's had enough and dismisses the case in the interests of justice, or until the defendant dies. Why should they be allowed to keep doing that? I think it's nonsense, it's BS, and that should be stopped. And of course, for most defendants, and Masterson is lucky that I don't think this applies to him, you run out of resources as time goes on. Maybe you spent a whole bunch of money on an attorney for the first trial. You spent all of your money in that, put all of your eggs in that basket, and now you don't have much left. So maybe you're now using the public defender. Maybe you can't afford your experts anymore. Injustice number two is that the defense in this retrial was prohibited from mentioning the testimony in the first trial. Now, how can that be? One of the only advantages to the defendant when they're being retried is the fact that you already have the testimony from the first trial. So the fact that the defense was stripped of this ability to use the testimony from the first trial is ridiculous and unjust. Injustice number three is that, at the first trial, the prosecution wanted to introduce evidence that Danny Masterson, scratch that, not evidence. They wanted to introduce the argument, the idea that Danny Masterson had drugged these three victims. But the judge said no. And the reason why the judge said no is because there is no real evidence that the women were ever drugged. At the retrial, though, at the second trial, the judge has allowed the prosecution to bring in argument that these women were drugged. There is no forensic evidence that the women were drugged. There's no toxicology report, urine test, blood test, sample from a glass, or any evidence whatsoever that there was any sort of drugging at all. Even the women themselves do not know whether or not they were drugged. So even their testimony that they felt like they maybe were drugged is not evidence that they were in fact drugged. Something else that I think is really important and really telling about the prosecution's claim that these women were drugged is that there's a law stating that it is a crime to have sex with a woman who has been drugged. Basically, what this provision of the penal code says is that it is a crime to have sex with somebody who is too intoxicated to resist, too intoxicated to consent, if you know or should know that they're intoxicated. So if the prosecution really believes that Masterson drugged these women, why not charge that? They know that they can't prove it, and they don't want to add crimes that they can't necessarily prove. If the jury looks at some of these charges and says, hey, this is BS, they really didn't present us much evidence of this, then the jury might start to think, okay, well, we know now that the prosecutor here is willing to charge the defendant with crimes, even though he knows he doesn't have enough evidence, so let's take a good look at these other charges too. And that's the last thing that the prosecutor wants, especially in a case like this where it all comes down to the testimony of 3 witnesses. Why should the prosecutor be able to stand up there and tell the jury that this is what Masterson did, that he drugged these women, that he prepared drinks for them, and he slipped a drug in their drink, and then he took advantage of them and he raped them? The prosecutor knows that they don't have enough evidence, and that shouldn't have been allowed, and that was a mistake on the part of the judge, in my opinion. Now, Masterson is facing potentially life in prison, so these details matter. And so, look, whether or not Masterson did this, I think that this trial has been effed up enough that I'm hoping that the jury sees these problems, that the jury sees the inconsistencies, and that they return a verdict of not guilty. I've been the attorney in a retrial before, and it was in front of the same judge that had presided over the first trial, and it was almost like that judge believed that, you know what, we got to see the same thing again, let's just get this over with, let's try to stack the cards against the defendant so we can actually get him this time and be done with the whole. It was the most frustrating trial that I've ever dealt with. It was insanity. And I believe that that's the same kind of thing that's going on here. Most of these judges are former DAs, and they see, okay, there wasn't enough to convict the first time. Well, let's stack the deck a little bit more in the prosecution's favor and a little bit more against the defendant so we can finally just wrap this whole thing up, convict him, throw him away, and throw away the key. I hope you found this video helpful. I hope you found it informative. If you agree with me or if you disagree with me, I would love to hear your thoughts on these things. I know that as a defense attorney, sometimes I kind of have blinders on, and so I'm very curious to hear other people's opinions, especially because you may be in a future jury pool of mine. And if you do have a criminal case in California and you want a consultation, feel free to give me a call. You can find my number down below. There's also a link there to book a call with me.